get on the record when you're ready. Okay, we're on the record this morning in Commonwealth versus Shelby Shell, Harlan Circuit Court number 13 CR 00076. And first question is that I wanted to go over is what the Commonwealth plans for today, and some ideas about, I want to get some ideas about, some just rough ideas about time frames and that kind of thing, just for my own purposes. And it's already my understanding the Commonwealth has some brief evidence to put on today. Is that correct, sir?
Brief evidence, summation with the Detective Cornett. He would be the witness to put on some evidence, and that would be it for the Commonwealth.
Okay.
Commonwealth's made an attempt to, we worked hard yesterday. We came in early.
We did.
And stayed late. Commonwealth tried to do its very best in getting its case presented in 2 days.
And then defense, again, rough time frame. I'm not holding your feet to the fire. Right. I'm not holding you to anything specifically. I just like to know for myself.
Is that all of our witnesses in the guilt-innocence phase would be finished by tomorrow? We'd have 2 experts planned for today, several family members, friends, other types of witnesses. And then tomorrow we have a sheriff, I believe the firefighting chief for Everett's Cleo Powers, and our investigator to kind of wrap that up. So I think we should just have 2 or 3 to finish tomorrow. We have the one DOC inmate who has a transport order and subpoena for tomorrow.
All right, and what about your expert?
So
I want to discuss
one expert is
that.
on intellectual disability and one expert is on special education.
And
both of those are an issue in this false confession case, and there's a wealth of case law on false confession and being allowed to present a defense expert in those cases, including Teague versus Commonwealth, which is a case that has been retried twice here in Bell County. So we just want to be clear that Fabian is relevant in the guilt phase.
well, let me ask you something. You said a wealth of case laws. Just a minute, Ms. There's no, as I understand it, there's no notice of intent to introduce evidence of mental disability.
No, there's no intent to introduce a mental health defense. This is not a guilty but mentally ill or insanity defense.
And there is actually case law that says you have to do that even in mitigation.
Which we're not doing.
Which we're not doing in mitigation either.
But I mean, I'd like to see the wealth of case law. At least I'd like to see the main stuff. And you say Keith v. Commonwealth?
Teague, T-I-G-U-E.
Huh?
It's the newest.
Teague, T-I-G-U-E. Teague.
C.
T-I-G-U-E.
Can you give me a site?
I can get a site, yes.
Well, I need to see it. I need to look at it before we allow anything like that. I want to know what I'm doing here.
Your Honor, if I may respond, from what I heard,
Teague. Teague v. Commonwealth.
In
Teague versus Commonwealth, yeah.
this case, she's saying that's a case, and she's talking about the case where there is a confession. This is not a confession case.
No, it's not.
I'm sorry, I believe that statement is being treated as a confession, so that's our defense.
Excuse me?
The statement was not made to any law enforcement body. He was not under any type of custody or incarceration, anything of that nature. This is not a confession case. There's been no notice of an insanity defense. There's been no notice of anything. The expert, one of which they're talking about, was utilized for the argument concerning the death penalty when that was an issue. The Commonwealth took the death penalty off the table because of that. That expert was utilized for that type of argument. Nothing thereafter has been placed forward. We don't have any objection, even despite the lack of notice, for the mitigation phase, which occurs in penalty. However, for the purpose of guilt, not only would we request that today, if they're going to put this person on, which we have no objection to, that it be outside of the jury and recorded until we can hash this out, but that we have an opportunity to brief the issue and inform the court of our arguments, which is not that, one, we're not in Harlan County. We don't have access to the internet right now. I don't have a computer that I can easily access the law. But from just the base knowledge, confession is a legal term of art. okay?
Well, the Teague case I'm familiar with involved not a confession, but a guilty plea where a guy wanted to withdraw his guilty plea, and the lawyer and had a standby lawyer who just sort of backed off, and
Yes.
that's the only Teague case I'm aware of.
The issues that we have looked at this morning.
If I can.
One at a time.
He responded to me, I'm still speaking.
Yeah, I'm
to him.
talking to Mr. Pete.
This morning, I briefly was able to look into this, and some of the issues that I saw with guilt phase mitigation concerned when the death penalty was on the table. It is not.
No, it's not.
It's under a specific rule regarding death penalty cases, which this no longer is.
No, it's not.
And so we would have, that is our objection, and we would simply wish, we have no objection to them having the witness here today, taping that, putting him on, going about their plan as they intend to do so. We just want the opportunity to brief the issue before that's played to the jury in guilt phase. And that's the entire purpose why we have tried to get through our case as quickly as we did, was so that they could get these people on today, but we don't want it in front of the jury yet. I understand that's the court's decision ultimately.
Well, I mean, if you're going to put on evidence of a mental disability of any kind before the jury, you have to give notice.
Can I vote with the site?
It's an unpublished case.
So let me tell you what the case
It's an unpublished case.
I'm sorry?
Is it unpublished?
No, it's published.
It's published.
You're not giving me
It may not be published yet. It may be to be published.
2017?
What happened was Teague versus Commonwealth, he entered a guilty plea. At the sentencing phase, he said, I want to take back that plea.
He wanted to
because my
withdraw his
lawyer
plea. I've
made me
read
do it."
that case.
So then they retried the entire case. And at the second trial, what happened was his whole defense was, I didn't make that confession voluntarily. And the opinion takes a long time to discuss the idea that false confessions exist and that people confess to crimes that they didn't do, and that the defense is entitled to experts to argue that. Now, Mr. Lee wants to say that confessions is a legal term of art, but it's not. He clearly confessed to Ernie Shell and to Jimbo Collins, and on the tape to Jimbo Collins. And we heard testimony yesterday that that was the exact reason that the officer went and got an arrest warrant and arrested him within hours. The entire reason he was arrested was because of the confession. So we have to have a defense on why he said the confession, and that's what our experts are here for. They're here to say that Mr. Shell has a disability, and that because of the lifetime of experiences and how he grew up and the way his brain works, he is gullible, he has a relationship with Ernie Shell, and that that confession has context. And that we are entitled to put that on as a defense in the guilt phase. And that's what we're saying here. We are not saying that he is guilty but mentally ill. We're not saying that he was too insane at the time of the crime to know
All right,
what he
let
was
me ask
doing.
you this. Is this
Those
the
are
wealth of
defenses.
case law?
I'm sorry?
Is this the wealth of case law?
No, there are
No,
other
there's
cases.
more. That's
I
just
will
the most
tell you,
current and-
I got Dr. Fabian's name from a case where he was excluded and it was reversed because they did not allow
Which
him
case
to
is that?
testify. Huh?
Which case is that?
I don't remember the case name. I just remember that's how I found Dr. Fabian. I'm sure I can look it up before the end of, the hour.
We would just request that the court pay particular attention to who this quote-unquote confession was made to. Was it a law enforcement entity or body, or was it a brother outside of any custodial arrangement? But nevertheless, our objection remains, and we would request that the testimony be made initially outside of the presence of the jury so that we can brief the issue.
Well, we'll know more later today.
Just to quickly respond to what Mr. Lee said, I think that's an argument they can make in closing arguments.
All right, just hang on. We're not there yet, okay? We're not there yet. I'm going to read this thing. The wealth of case law in this unpublished opinion.
It's
So, let's see, it's about 5 till. Are we ready to get going?
Yes, Your Honor.
Let's go ahead and bring the jury in. Let's just bring the... Is there anything else?
I believe that Ernie Shell was on Facebook all last night. I just wanted to bring that to the court's attention. He's not testifying today.
Ernie Shell? I thought he was excused.
No, he's subject to
He's subject to recall. Well, he's not supposed to be on Facebook. I'll tell him not to be on Facebook.
Your Honor, we've told him, I know even Detective Cornett told him before you entered the order,
I never
heard
got an order to
Detective Cornett
sign.
tell him.
You were going to tender an order to me, and I never got it.
Yeah, it's my fault. I didn't do that.
Okay, well, he's never been ordered not to be on Facebook.
He has by Detective Cornett.
Okay.
And he was in court.
And so I don't know if he was, I don't know, I'm not on Facebook.
I'm not either. I don't know how to get on.
In fact, I don't even know how Ms. Hudson or where she posted those photos, but I heard
I
about
took them
those.
down, Judge, I was just talking
Okay,
about
thank
how
you.
both
Thank
teams
you. No
worked so
photos.
well,
Right,
looked
thank
so
you.
good, but I took it down.
Thank you. Yeah. Facebook's turned into a curse. I mean, is that it? Let's bring the jury on in.
Judge, we're still 2 jurors short.
Okay, let's wait till we get here, and we don't want to get ahead of ourselves.
We go in first if they're going.
We don't want to go without the potential alternates, so.
Judge, we're coming to the metal detector in the street. They're on their way.
Okay, all right. We had a hard time counting 12 yesterday.
We did.
Yeah.
I went back and reviewed my number skills.
Well, it's tough.
She can get inside the company. Phrase a question for her. She sent it to me. I think it's correct.
Oh, okay. Is this a jury?
It's just,
No, this is not.
she didn't.
I had a really jar here to him, I guess, like he did for us.
They've had trouble trying to get the infrastructure.
Last judge stands with him.
There's nothing in this call except for the fact
It's in November. It's got a Southwest 13. T.
and I don't think the definitely was in front of TV, was it? Yes, it was.
Okay, I believe it's the jury coming in now. All rise for the jury, please. All right, let's all be seated. You have anything to report back, committee? Anyone? All right. Hope you all had a nice rest yesterday evening. And we're making some pretty good progress here, and hope to make more today. We did well yesterday. All right, I guess at this point, Commonwealth wants to call its next witness. We'll get going.
Thank you, ma'am. Please report. Call Detective Michael Cornett.
All right, Mr. Cornett, you're still under oath, of course.
Yes, sir, Your Honor.
Have a seat. All right, Mr. Bond, go ahead.
Thank you. Detective Cornett, to bring us back to where your investigation continued in this case, we've introduced the evidence from the search warrant and then the arrest of the defendant. Did you, in continuing your investigation, could you just briefly summarize for the jury what you did finally, or were there any other evidence that was part of your case? Any statements that you saw on television or anything like that assisted you in putting your investigation together?
Yes. Shelby Shell, after being arrested, was transported to the Harlan County Detention Center in Harlan County. I interviewed Mr. Shell at the detention center. I read him his Miranda rights prior to any statement being taken or recorded. He refused to sign the Miranda rights waiver. The conversation was recorded. He stated that his brother Ernie Shell had set him up to take the fall for Ronnie King's murder. That Ernie Shell had the gun, and that Shelby Shell did hold it, but it did not belong to him. Ernie Shell had given him the jewelry that had been recovered from him at the time of his arrest, and the jacket with the bullets, the change, and all belongs to Ernie Shell. He states that he was with his wife on February 17th, and they were on their way to play bingo. When I asked him where they played bingo at, so I could confirm his whereabouts, he states that they didn't make it to the bingo hall because they got into an argument. Later discovered that Mr. Shell gave a videotaped interview with WYMT TV, and he states that he was at work. I checked with his work, CQIS Incorporated, or business in Berea, and according to his immediate supervisor, Lee Miller, he was not at work on the 17th or the day before, or he was not at work the day before, on the date, the day before, or the day after.
Now, let me ask you about that. He had indicated that he was at work to you?
He indicated at the WYMT that he was
On the
at work.
WYMT, he said he was working.
Yes.
But that was a voluntary statement he made to the press.
Yes, sir.
So you felt it was your obligation to check out his work, is that correct?
Yes, sir.
And I believe I heard you tell the jury that, who did you talk with?
Lee Miller,
And who was Lee Miller?
his immediate supervisor at CQIS in Berea.
Did he confirm that Shelby Shell did work at some time for that organization?
Yes.
But on the dates that were relevant, the 17th of February 17, 2013, and February 18, the day the body was discovered, 2013, he was not at work.
That's what he told me, yes, sir.
So, did you continue with trying to verify other alibis that you may have become aware of?
At some point, Mr. Shell said that he and his wife went to a McDonald's. If I'm not mistaken, I think it was in London. I checked with that McDonald's to see if they had any security video footage of the drive-through, and they had none at all.
You were questioned yesterday about things you didn't do and things you did do. Was it relevant for you to go immediately and check with the McDonald's security cameras?
Not immediately, but sometime after that.
And they had it, and you were able to check it, is that correct?
Not at McDonald's, no, sir. I think Mr. Shell may have had a receipt in his pocket with a date. I can't remember the exact date, but I checked with it's fax from the Madison County Public Library. I think that may have been in Berea. I checked with them and got the security footage from their video during that time.
Of the library.
Of the library.
He had a receipt that he had sent a fax. Is that what you're saying, or
Yes, it had a date on it, and I was trying to confirm that.
Who had put the date on it?
I have to look and find it, sir. I can't.
I mean, what kind of receipt was it?
I think the thing that interested me was it was a fax, maybe a letter or a fax that had a date on it, and when I checked with the library, the date on their fax machine was off.
The date at the top of the page.
Yes.
It was off.
Yes,
Not set to the correct date.
that's correct.
Other relevant facts in that you, as you concluded your investigation.
I just went to WYMT and got a copy of the interview.
Did you take photos of there's a lot of things in bags, and you showed some yesterday to the jury. Did you take photos of the items that you seized at the time of the arrest and subject to the arrest warrant?
Yes, sir.
May I approach, Your Honor?
Mm-hmm.
I'd ask you, and we'll see if we can turn the machine on. See Lena.
Says Lynn. Okay, sir.
Yeah, please. Thank you. On this, well, we don't have the light on. Let's turn. There we go. So that. I'm just going to briefly go through this. Did you recognize those photos? Detective Cornett.
Yes, sir.
They're not up yet. Let's see. There we go. There we go.
Did you take those photos?
Yes, sir, I did.
And what are they? When did you take the photos?
On February the 25th, on the date the search warrant was executed.
And again, where were these photos taken?
At the time of the search warrant was executed in Berea.
At the Shelby Shell residence and at his
Been outside of his residence.
at his vehicle.
Yes.
Okay. Could you just briefly go through? And Your Honor, we've identified them. We will be moving to introduce them as collective 11, I think, isn't it? 12. Collective 12 of these photos. Just briefly, the jury can see them, counsel can see them. What these depicted are of these photos that you have all these been introduced earlier, the actual product, the actual as evidence?
Yes, sir.
Okay, so make sure that what you show are things that have been put into evidence, okay?
Yes, sir.
Thank you.
This is the gold chain. This is the black paper clip. This is the silver ring that showed yesterday. Here, 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 and here is some jewelry that's been damaged, beaten, folded. You can see this ring here is folded. Here, I think that may be a ruby that I made mention of. Here, and there's a ruby. Here, I don't know if they were earrings or if they were settings from this silver ring.
This was silver and gold.
Silver and gold, yes, sir.
Okay. I think you have some other photos that are maybe closer.
Over here is the white cell phone that was recovered.
All those were in Exhibit 9, in the collected Exhibit 9. Just briefly, what was that?
This is the what appears to be a men's Kentucky cluster ring, or I will say a Kentucky cluster ring. I don't know if it's a man or a woman. Then here in the corner is some loose diamonds. It appears to have been damaged, mangled, destroyed. That was in the Ziploc bag that showed the jury yesterday.
From the, I think it's Exhibit 911, jewelry, black cloth bag. It was inside the black cloth bag.
Yes, sir.
Yeah. It was difficult for them to see, and I just thought it would be helpful to see how you collected that. A few more photos, please.
Up here in the corner, or the top of the page, is the black silk bag that all this was in. This is a better look at the silver ring. It appears that there should have been some settings along the edge here. Here's a red ruby. Like I said, I don't know if that came from that ring, but then here's the gold necklace again. Over here in the corner is another of the beaten, damaged gold rings.
Please continue. What was this to depict?
I figure the best way to get in there. Okay, this is just the same jewelry, just spread out more so you can see it better. The gold necklace, the damaged parts of the ring, appears the silver ring. Here appears to be ruby settings that possibly belong in that ring, and then here's the black paper clip.
Next.
And then here's the corner is the black bag that came out of, and the white phone that was also seized. This will be the front passenger side seat. Here is the sock that's wrapped in plastic.
Could you turn that the other way? It's showing on the picture upside down. There.
Better.
That's better.
Better.
Yes, that's.
Okay.
Okay, what was that?
This is the front passenger side seat of the 2001 black Ford pickup.
And that's where the pennies were.
Yes, this was the penny. It was inside of a sock.
The wheat penny, and I think you identified as a piece of script from Yoakum Creek Coal there in Harlan
Yes.
County.
That was all inside there, wrapped up in plastic.
That's where it was when you found it.
Yes.
Continue on. Just show the other items where they were, just to give the jury a better idea of how you found them and where they were when you found them.
Just a closer up view of the same bag. I'm trying to.
Okay.
Don't work exactly right.
Next.
This is a picture of a light gray zippered hoodie with a box of Smith & Wesson 38 caliber ammunition in the pocket.
And the hood, and that's a gray hoodie.
That's a gray
you're
hoodie,
talking
yes.
about.
And here it is, displayed on the back of the truck. Same hoodie with the same box of bullets.
Go ahead.
This is the gas can that was presented. That was in the floorboard, rear passenger compartment floorboard behind the passenger side seat.
Okay, next. Just go through them just as you can sort of continue. I want to move for them to be an exhibit. I just need you to identify them, that they were all things that you took.
This is a Marlboro cigarette box that had 38 caliber ammunition
In a cigarette box.
in a cigarette box, yes. And if I'm not mistaken, I think that was recovered from the passenger side front door. And this is where the bullets was recovered from. Here you can see the Marlboro box. This is the passenger side front door where it had the electric window controls. If you lift that up, down inside inside the door panel is where I recovered those. This is appears to be the same light gray hoodie, and then the other pocket is a box of Winchester 38 Special grain. Try to get that where y'all can see it. There it is. 38 caliber special plus P 38 caliber ammunition.
Were those boxes full or empty? Were there any missing?
I'd have to look.
They're in the evidence.
Yeah, I think some of them are partially empty.
Any other photos?
Those are not that you provided me to show.
Are all of those introduced during the collective exhibit? I think not. So this has been collected. We looked to introduce these photos to support those items.
That would be collected 12.
This is 12.
Any objection?
No.
They're already in evidence, these items are, I believe. All right, they're introduced as collective K.N.S. Exhibit 12 without objection.
Just to aid the jury if they don't want to go through all that to see those items. You mentioned that you saw an interview you gave with WYMT.
All right, would counsel approach, please?